So hi, thanks so much for watching this video. I'd like to introduce the fabulous Sarah Dowie, who's joining me this evening in this series of Meet the Expert videos that we're doing. Sarah, I met you at the WIBM meeting in Liverpool Street last year now. And do you want to just give us a flavour of what you do?
So I'm a family solicitor based at Palmer's Solicitors in the Rayleigh office. We do have other offices. We have two in Basildon, one on the Mayflower estate called Phoenix House, and one at Thurrock, which is quite near to Lakeside if you like your shopping, and another office at Southwood and Ferrers. In terms of what I do, it's all things family. So it's divorce, it's finances for couples that are married or not married, anything relating to children, and domestic violence. For couples that have separated, that aren't married and having a bit of a disagreement about the property and who owns it, I deal with those as well.
And I think that's where we kind of found our synergy a little bit, because what you do can absolutely help the clients that I'm working with on a daily basis. So it always sometimes seems a bit scary to go and talk to a solicitor about protecting your assets. I'm dealing with clients who are buying their first homes together, or they're moving in, or they're whatever, consolidating finances. And for me to be saying to them that you need to go and get something in place to protect things if something goes wrong in the future feels like a really hard thing to do. And then for them to have to pay for that as well. So just
Absolutely.
kind of wanted to get it out there that actually sometimes just deal with it while you like each other. As you mentioned to me earlier, it's a lot nicer to have those conversations while you're being friendly and civil to each other rather than in the future. And a small investment to protect yourself now, especially where you've got like a mismatch of deposits or something.
Which is common, isn't it?
Exactly, it really is. Yeah, it can really protect you in the future. So I would recommend everybody absolutely think about this. So the idea of this video is to just dispel some of the myths and understand that you're not lovely and approachable, just like I am, and it shouldn't be something they should shy away from. They should at least find out about it. Okay?
Definitely.
So I should have said right at the beginning, I'm Sam from My Mortgage Angel, so thank you for watching this video. I'm not a professional at videos at all. I hate doing them, but I think they have a value in this world now, so I am pushing myself out of my comfort zones. So I've got a couple of scenarios that I'm going to ask you about, Sarah, which I think are fairly typical of a lot of clients I've had recently contact me. So completely anonymous, so I'm going to use Alex and Ashley in these scenarios. So Alex and Ashley here, they're going to buy their first home together. They've both got some individual savings, and they've also got some joint savings. One of them earns more than the other, and then the other one's got a slightly larger deposit. So in that scenario, if I've managed to convince them to come and talk to you and have a grown-up conversation, what kind of advice would you be giving them?
So I would probably recommend that they enter into a declaration of trust, which can be drafted by one of my colleagues in the wills and probate team. Essentially, it's a document where they can record their unequal contributions. They can set out whether or not they want to get that back as a fixed sum, get it back as a percentage, what would happen if the property price falls, how they're going to deal with that. If the relationship breaks down and one says, I want to sell, how do you deal with that? In that scenario, one might want to buy the other one out. So you might want right of first refusal, but you might want to time limit that. And then it goes to open market, so that as a couple, you know that at some stage you're going to be able to separate and move on. I can understand that when you're purchasing a property, there are a lot of expenses, and it can feel like just another unnecessary expense, something you want to shelf, something you don't necessarily want to think about. But just imagine, we are making deposits on properties that are very large in nature. And do you really want to put tens of thousands of pounds at risk when you could just have a conversation? You can come and see me or one of my colleagues. We'll give you some bespoke advice, and then we'll draft the document for you. And we can cover off most, things that might be worrying you, so that you don't have to worry about this. Because what I can say as a divorce lawyer is that things are raw. When the relationship is breaking down, people can become unreasonable, and sometimes they can say, well, I'm not agreeing to that anymore, particularly if there's been some infidelity or something of that nature that can make them quite upset. So don't leave it until it's broken down. Have a document that just means that you've, both got something that you can refer to. It can be possible for these documents to be set aside, but you both get legal advice to improve the prospects of that not happening. And again, I understand that, in terms of costs, people might be thinking, can't add any more, totally full. But from about £900 inclusive of that, you can get advice from me or one of my colleagues. And it depends on how complex it is, but I would say that the majority of the people that I see one property that they want to protect, and so it comes in at the lower end.
That's really reasonable, actually. Some of the mortgages that I'm looking at, the lender fees are more expensive than that. So yeah, in the scheme of things, it's not, but really not that expensive at all. And something I was thinking of when you were talking about that, if the breakdown happens really in the future, sometimes we look back on things with we haven't got clarity of exactly what happened. So one party might remember that you had a bigger deposit than the other, or the figures might get muddled over time. So actually protect both parties to just get it written down and done. And it doesn't necessarily have to be registered, does it? So it doesn't have to be a public document. You can just be held.
It can. I mean, we often advise that you do. We've got restrictions, as they're called, which are essentially written items that go onto your legal title, where it will show that there is a trust between you and the other owner, and it just is a way of loud hailing to anybody that's coming across your property in the public domain that there are two owners and that they might have unequal shares, and that can be recorded on your legal document called the transfer that you sign when you're buying from one party for yourself.
Yeah.
But what I will say is that memories can fade and there can be misunderstandings, and we also use really odd terminology for owning a property. We refer to a tenancy. Most people think that relates to a rental property, but when you own property jointly with somebody else, you are either tenants in common or you are joint tenants. Just so that you know what the difference is, if you're joint tenants, if one of you passes away, it will automatically pass to the other party outside of your will. But if you're tenants in common, which is far better for unequal shares, you can set out on that transfer document that I referred to before, how much each party owns. It might be 60-40, for example. And then you can have the declaration of trust that really sets out the nuts and bolts of how your legal relationship will work. And actually, because of all of this, I think very confusing terminology, which is, in amongst all of the other confusing terminology when, talking to lenders and trying to take everything on board, it's better to just know that you've got a document where you've both had legal advice, both set out what it is you're trying to achieve.
Yeah, fantastic. Thank you so much for that, Sarah. I'm going to move on to situation number 2. I'm going to stick with Alex and Ashley. So again, they're buying a new home together because, let's face it, that's what I'm a mortgage advisor. So most of what I do is people buying houses together, which is what I love. They've both...
You see them when they're happy, don't you, my dear?
I know. You get them when they're sad and I get them when they're happy. So I do actually work with quite a lot of divorcees as well. So I kind of see the other side of it, where people haven't put these things into place and then they're pressed of looking for what they can borrow because they haven't got as much out of the property as they would have expected or even entitled to. So it's not always happy, but they always leave me happy.
Good. And more your way.
Yeah. So Alex and Ashley are buying a new home together. They've both saved deposits as well, but we've got parents who are gifting money because obviously sometimes deposits are sometimes a little bit out of reach of just children on their own when they're buying their first home. And sometimes parents don't want to wait for their kids to save that amount of money. So they would give them some money to make them move out a little bit quicker. But what we're looking to do in that scenario is kind of protect that money from the parents. So if there was a separation, this person gets their parents' money and this person gets their parents' money. The parents are not wanting the money back. They just want to make sure it stays with their child. So is there a way that you can cope with that situation as well?
Yeah, there certainly is. It's likely to be the declaration of trust again. And with the declaration of trust, we predominantly use that in scenarios like this or the last one where the couple is unmarried. And actually, it's I get these requests as well. You know, people and parents, grandparents, they just want to know that what I've gifted will stay with the family member that I've gifted it to, and you can use that declaration of trust. You're just adding in more terms to reflect that in the way that I've described previously. And probably what I should say at this point is, if you're married, you can have a different document, which is a prenuptial agreement. It's much more detailed, and as a result more expensive, because you have full and frank disclosure financially. You don't necessarily do that with the declaration of trust, but because divorce law is far more complicated than it is for just, well, I say unmarried couples, friends, anybody who is just buying a property with someone to whom they are not married. Declaration of trust is probably the better vehicle. So now that I've introduced the idea of prenuptial or even postnuptial agreements, I deal with both, as does another colleague here at my firm. You're looking at a cost of from £1,800 up to about £2,500 inclusive of that. And again, it's all depends on the complexity of your situation. And what I would say for anyone who's thinking, wow, scary figures again, come and see me, come and have a fixed fee appointment. Sometimes I can find a document that better suits your financial needs, but better to have a document than nothing at all.
Absolutely, definitely. And we were just talking before this about other situations that may arrive, and you were talking about a situation where maybe somebody's moving into your property. So I see quite a lot of families wanting to move together, especially after COVID. A lot of the parents felt really estranged, and actually they're getting older and they need a little bit of help. So I've helped quite a lot of families where maybe the parents moving in, maybe they're contributing towards the house, maybe they're not. But in that situation where they're not actually buying a share of the property, they're just kind of renting a room or something, where the families can all live together. That's something you can help with as well, isn't it?
Indeed, it is. Quite often it can be a document called a deed of surrender and release. I had the very scenario that you're talking about, where a lady was moving in with her daughter and her husband, and she was actually going to fund an annex, but she wanted no interest in the property, and they wanted to record that because she was making a will at the same time. She had more than one child, wanted to make sure that the children all knew the situation financially, and that her daughter and her husband would have a document that would show that actually I have no interest in their house. And I think this is really important because, again, when somebody passes away, it's an extremely fraught time, and you do not want to be having conversations then about what did mum want, what did mum intend. And often people will say to me, surely my mum intended me to have a bit of my sister's house. Why wouldn't she? You know, but
You almost hear it, can't you?
absolutely. And they're so destructive. And actually, having this document means that you can have these discussions. The document can be circulated amongst the family members. Everybody knows where they stand. And that doesn't mean, again, that there can't be legal claims made. Of course there can. But if you've got independent legal advice for the parties to the document, and you're priming, I would say, those family members that might otherwise feel cheated by the scenario because they weren't privy to those conversations, you really can bring the temperature down when you're all grieving and you don't really want to be having those nasties. Or you might have a scenario where, unfortunately, the family member that moved in has got to go into some sort of residential care, and you want to make sure that you have made very clear what the legal position is. And again, why colleagues in the wills and probate department can give very bespoke advice around that particular issue, because care home fees are horrifying. So it's important, again, for people to just have that advice, those thoughts about what they're intending, because I think that's where court applications arise. We don't always really expressly think about what we're doing. We're just getting along as a family. We're just moving in. So have that chat, have that conversation, and then hopefully, because everybody else, those parties to the document and the wider family, understand the legal relationship that you're actually creating, that, you know, you can all have a bit more peace in lifetime and, you know, in the unfortunate position of death as well.
Yeah, I suppose creating that opportunity to discuss it as a family, you can talk it through with that parent and you can put your side of the argument forward so that you've had that discussion, rather than when it's too late, you can't put over your point of view, can you? So I think that's a really important thing to do.
Absolutely. You know, little things like how are you going to split the bills?
Oh yeah,
You know,
everyone likes to talk about that.
absolutely. No, they don't. And, you know, something, and actually, it's far better to think about these things before you get your horrifying gas bill for the winter quarter. And
Yeah, because
suddenly
grandma's
you're
had
on
the
to pay
heating on
half.
100 degrees for a year.
Exactly. So, you know, it's just good to cast your mind to these things.
Yeah,
So again, in terms of costs, you're probably looking at a starting point of around £900 inclusive of that, again, dependent on your personal circumstances. And it's always best to come and see us, come and have an initial meeting with us. We often offer fixed fees for initial meetings. I certainly do. And in that meeting, you can give me a lot of information, I can give you advice, and then we can steer you as to what document might be best for you.
brilliant. Are there any other scenarios that I haven't thought about? I've probably come across them, but where you think you can add some value to my clients, Sarah?
I would say a cohabitation agreement. It's a great document. It's got bells, it's got whistles. You know, who's paying the gas, who's paying the electric. If the relationship breaks down, how quickly, you know, you're going to move out, that sort of thing. Expensive, I accept, to prepare one of these documents because it covers off all sorts of scenarios. But if you are a couple that is moving in together, be it, you might have one moving into the other's property. You might be selling one property and moving into the other that's owned by the other party. The cohabitation agreement has its part to play, and that's again why I'm saying come and get that initial advice. We can say to you, you need all the bells and whistles, or you can have, you know, something that, you know, still does the job but just isn't as extensive. Because I would say that a cohabitation agreement is probably for your clients that have got, you know, multiple assets and really want to make sure they're being very clear about, you know, for example, I've got this here, you've got that over there, and this is mine, we're sharing this, and that is yours. And again, just means that you do not have to have these conversations when the relationship is broken down. And what I find is that sometimes people feel that there's this moral obligation. Oh, I thought he was going to look after me, but they haven't had that express conversation. Better to do it.
Yeah.
You're not making your life plans around something that you believe they are going to provide for you, but may not necessarily intend, you know, to do so.
Yeah, definitely. And probably in the event of a breakdown, especially I've seen it where couples don't even talk and they're all talking through solicitors, to be challenging and having those arguments where you're paying solicitors to argue for you, the bills can just go absolutely through the roof.
So I'll give you a bit of an anecdotal
I
example.
thought you had a story here.
Recently received instructions from one party to a separating unmarried couple who had entered into a declaration of trust. And I have to sing the praises of my colleague Helen Jago, whose precedent the document was, and it covered all the things it needed to cover. It covered whether it was a percentage, whether it was a fixed fee, what would happen if the price fell below what they had paid for it. Actually, sadly, in this scenario, they bought the property just over a year after they'd purchased it. And these parties were very sensible. You know, they were able to agree some things that you wouldn't normally put in the document. For example, you've got your early repayment charges. As you well know, Sam, some of the rates that you were getting a few years ago, you're not getting anymore.
Definitely not.
Absolutely. And they were able to sensibly agree, you know, that essentially one party was going to keep the mortgage going and a sale would happen at a later date when that rate expired. And actually, I consider that because these were parties that had had a conversation at the point of purchase, it actually wasn't difficult for them to then talk about that when the relationship had broken down, because the seeds had been sown. And, you know, if anybody's cringing at the thought of having to talk to their partner about money, because let's face it, some partnerships, they've got no idea what the other party's earning. I'm sure you've seen this, Sam. They come to see you and they're making disclosures, and one sort of looks at the other and says, "Oh, how much?"
And credit cards, that's another one.
But it's a great crossroads, a fantastic opportunity for parties to just have a review of where they are. It doesn't need to be difficult. It doesn't need to be cringy. You know, if you were entering into a business relationship, you wouldn't cringe for a moment. You'd be more than happy to have these frank conversations. And actually, for the client that I'm describing, they both had the piece of this document now governs what's happening.
Yep.
And we can just get on with uncoupling.
Yes, takes the emotion out of it because you've already had those thoughts and dealt with it. And
you know what? That client paid to come and see me for an initial fixed fee, which at the time, £258. He hasn't needed much more advice from me. Whereas you've got a couple that you know, haven't had those conversations, particularly where you've got unequal contributions, which is why this couple had that document. I can tell you now, the party who puts in more always feels aggrieved. They might have thought they were happy to share,
yes,
and then they decide after the event that they're not, and it's too late. So come and get the advice from me before you sign on the dotted line.
Absolutely. Or allow that person to move in with you.
Absolutely.
Yeah. Okay.
I should say cohabitation agreement. That is probably between £1,800 to £2,500, and again, I totally accept, you know, the gravity of these figures. But as I say, come and get that initial advice. You can always decide, you know, what document is right for you.
Yeah.
And actually, Sam, what I would also say is that so many couples that I encounter will have a declaration of trust for, say, an early property that they buy, and then they buy a second, sell that one, buy another one, or a third, and they move on. And sometimes they allow that document to lapse. Sometimes I've had frank conversations about it, other times they haven't.
Yeah.
And again, you should come and get advice, because there's no harm in having, you know, a document between you that makes it very clear that, you know, we're not doing that anymore. We had unequal shares before, and now we're sharing equally. Yeah. Go forward. And again, just takes the sting out.
Yeah,
in the
definitely.
break it down.
Yeah. Oh, fantastic. Well, I've learned a lot more as well. So I always enjoy talking to you, Sarah. Thank you so much for your time. What we'll do at the end of this is we'll put a slide on that gives out your contact details. We need to say that we're recording this on the 5th of March 2004. So all the prices we're quoting.
2024. I'll go back to 2004 though.
Oh, sorry.
I'm looking much better than I do now.
They might have been the same costs. I'm sure you haven't put them up for a while. 2024, yes. And then if anybody wants to get in touch with you or me to talk about anything, we do a lot of cross-referring as well. So yes, thank you so much for your time and for your knowledge. And who'd have thought we'd have been laughing through this?
I know. What I can say is that I can make shoveling misery funny.
Lovely. Really lovely to chat with you, Sarah. Thank you so much for your time. And I'll see you at the next WINBN meeting.
Absolutely. Lovely to see you too, Sam. All the best. And thank you.
Brilliant. Thank you. Bye.
Bye.